Okay, let's start. Good morning, everyone. Thank you for joining for this OpenAIRE webinar. We will have 1 hour webinar with so short presentations and then question and answers moment. So we want to have time to answer questions. We have some questions already that you have sent us via the registration form, but you can also put other questions. So use the question and answer button to ask questions. You can ask questions during the presentations from the speakers, from Thomas and Prodromos, but we will try to answer the questions after the presentations. But if you have a question just in the moment that they are presenting, you can just put the question and we will answer at the end. So it's really a pleasure to have so many participants and so many people interested in this webinar. So the webinar, we will have Thomas Margoni from Glasgow University and Prodromos Tsiavos from Athena Research and Innovation Center. We are all part of the OpenAIRE team, collaborating in different areas of OpenAIRE, from the training and the policy activities to also some support to technical activities. And we will run this webinar. So I will give in 3-4 minutes really a short overview about the support materials that OpenAIRE have available, focusing on the new support materials that we have related with the legal issue and RDM issues. And then we will have Thomas Margoni presenting the guides and the content that we have from copyright licensing and research data guides, and then addressing the issues related with personal data in open science. Prodromos will also present the guides, the content, and highlight some of the main issues that we have when we address this kind of topics. And then we have already selected some questions and answers from the registration form, and you can also put other questions during the webinar. So OpenAIRE have an open science help desk. We run the help desk based on different kinds of support tools. So we have some support materials like the guides that we are presenting today, fact sheets, FAQs. We have a ticket system that all the users, from researchers to research support staff, can use to ask questions. And of course, we have a direct support at the national level run by the National Open Access Desks. We have several activities related with, so specifically training activities, so like webinars like we are doing today, and workshops. We have several workshops already planned for 2019. Please check the agenda in the OpenAIRE portal. And we have also some activities around all the support and training for the new OpenAIRE services and products. Specifically, so we have several support materials related with the issues that we are discussing today, so the legal issues, and also around research data sharing and management. So we have, I would like to highlight that we have 2 primers, so where we have a kind of the basics about open science, open access to publications, and research data management. We have the guides. So I really want to highlight that we are updating the guide section in the portal like every month. We since October that we have released the new OpenAIRE portal. Every month we have 2 or 3 new guides, and we will have the same until the summer. For sure, you will find new guides targeting different stakeholders and approach, related with different topics, you can check the portal, and also, as I said, check the agenda of the workshops. We have several fact sheets, and so we are always updating also the FAQs. And all these new materials are also due to the fact that now we are pushing to have like a kind of task forces to build more capacity on the three main areas: research, data management, open science policies, and the legal issues. And the result of this push to have more support and training content related with legal is the fact that we now have several guides, new guides available, and this is what we want to present you during this this webinar, to highlight the new guides that we have related with copyright, licensing, and personal data that we have available already in the portal. So we will focus mainly in these four guides, and then other topics that Thomas and Prodromos will identify as relevant for all of us. So how do I know if my research data is protected? How do I license my research data, and can I reuse someone else's research data? Are the guides that we will highlight related with copyright and licensing, and then related with data protection and open science, how to deal with sensitive data, and Prodromos will for sure identify more relevant topics that we need to focus on for the work we are doing in our projects as a researcher, and then also as research support staff that need to provide support to researchers and project coordinators in our institutions. So now I will give the floor to Thomas to present himself if he wants, and also of course to detail and to present the guides that we have specifically addressing copyright and licensing issues. So please, Thomas, you can now share your screen and start your presentation.
Thank you very much, Pedro. Thank you for the kind introduction. So let me share my screen first. Okay. So I have a couple of slides. Well, good morning, everyone, first of all, and thank you for joining us in such a great number. I have a couple of slides that I think are useful just to set the stage, and then I will move directly through, we could call it a live demonstration of the guides that Pedro just referred to. I think it's interesting to show how, where the guides are, we already have the links, but have a visual feedback and have a quick overlook of what kind of information they cover. This could also form the basis for additional Q&As later on. I think that is important to clarify right away a few terminological aspects, because obviously there are many, but at least two main dimensions here. The dimension, the point of view, the approach, the understanding of the researcher, so the scientific community, and what they mean by, what you mean by research, what we mean by research data. And then there is the law. And the law has a completely different definition and viewing of what research data and databases are. And I think this is a first major element that has to be addressed, because often it happens that we think we're talking about the same things because they have the same name, data or research data. But as a matter of fact, in our hands, in our mind, in our disciplines, we are talking about very different things. And this is a first cause of frustration. So here I have just a couple of very basic points, but I think they are instrumental to what we're going to say later on. There is no clear legal definition of what research data are. There is no a Copyright Act or a Research Data Act saying research data is. So it's a matter of norms, often community, scientific, academic norms to define what research data are. But as we know, these kind of norms are not engraved in stone. They are fluid. They may change over time, over discipline, and over jurisdiction. Do we have at least a definition of what data are from a legal point of view? Partially. The law talks about data, but talks about data in many different ways. It may refer to copyright aspects, to related rights to copyright, to other IP rights, to personal data. And in all these cases, even though you may think, well, it's data, as a researcher, I don't really know how a discipline that is not mine defines a certain concept. I just need to know what I can do. Can I do this? Yes or no? This is not my job. This is something that someone else should do and should give me a clear answer. That's what we're trying to do. It's not easy. It's not easy because the law attaches very, very different consequences to different categorization. And this is what we're trying to do today and throughout the guides. But I think that right now, what is really important to understand is that it's not sufficient, even for you as researchers or as PIs, it's not sufficient to say, well, this is data. You have to go a step further. It may not be what you want to hear, but if you go a step further, it's going to be a lot easier for all of us, including for us, for the legal expert, to give you more specific feedback on what you need to do. Having clarified this introductory aspect, in the first part of this presentation, I will be focusing on aspect of copyright, related rights, database, and licensing issues. Whereas in the second part, Prodromos will be talking about personal data. And the reason why we treat them separately is because, believing it or not, they are very different legal concepts and they behave in very, very different ways. And this is a very important aspect to keep in mind once again. So we have produced, from the, let's say, copyright point of view, 3 main guides that I will show to you in a moment from the portal. The first one is, how do I know if my research data is protected? The second one is, they should follow some sort of logical narrative. First of all, you need to know whether what you have is protected. Once you know whether and how it is protected, you want to know how you can license it, meaning how you can tell other people how to use it. And finally, when it's you who wants to reuse someone else's research data, what do you need to know? To complement these 3 guides, we have an additional companion guide that tackles directly repositories, but is something that I would nevertheless recommend you to have a look at, especially if you are in charge or in coordination of research projects, which is how to make your repository open science compliant. It includes a lot of additional information on licensing aspects, but it's perhaps a bit more, it has a lot more detail, it can get a bit more complicated. So your starting point should be the first 3 guides. And then if you are still liking it and you are not extremely bored, you can move to the 4th one. So let's move to the guides. I'm stopping for a second the sharing because I think that's the only way that I know how to do this. Okay, so hopefully everything worked fine and we are all seeing the first guide.
Yes. It's everything okay.
Great. Thank you for the feedback. So how do I know if my research data is protected is the first guide. As you see, we try to be as concise as possible because after many years of research, we finally came to the conclusion that people don't like to read hundreds of pages of legal analysis, which is surprising because it's very interesting legal analysis, but it turns out that no one really reads them. So how can we, and this is not a trivial question, how can we distillate so many details, so much complexity in a way that can be easily understood by people, by researchers who do this every day, but who should not be excessively concerned in terms of knowledge cost and time cost in the legal dimension of their research activity. So this is the idea behind these guides. And we're very eager to know your opinions, your feedback on any aspect. As Pedro said, we are constantly developing the guides, not only content-wise, but also in terms of graphics, how to make them even easier to understand. We will probably in the future implement visuals, etc. But obviously, for this, your opinion would be very, very useful. So please feel free to share your views on this. Now, regarding the content, obviously here, as I mentioned at the beginning, we do have a few questions on what is research data, and once we can, if not precisely define it, at least have a common core of situations where we say, okay, this is research data, then the following question is, well, how is it protected? When is it protected? Is it always protected? Obviously, I will not go through all the text. We don't have the time, and I think it wouldn't be very useful. But I invite you to go through it. What I will offer you is a general overview of how to determine or what are the main legal issues here. So, as we were saying, the law doesn't really have a definition of data. It doesn't have a definition of data sets either, but the law defines databases. And that's something that also has to be kept in mind. The law has a definition of database, and when we speak about legal issues, we have to make sure that we only call databases what the law defines databases. Because otherwise we're again talking about different things, and therefore we may not understand each other. So here I have the definition of the law. It's, as you see, quite broadly, is a collection of independent works, data, or other materials are arranged in a systematic or methodological way and individually accessible by electronic or other means. This is an extremely important definition because either we have this structure of independent works. So here independent works means that a literary work, so a text, a poem, an article cannot be a database because there is no, there are not independent works and they are not individually accessible. There is a narrative sequence that has to be followed in a literary work. Just to give you an example of works. So works here means something that is protected by copyright. Imagine a database of scientific articles. Data, not really defined, but something that is not work. So measurements, numbers, everything you can think of could potentially fit into this definition of data, or other materials, but they have to be arranged in a systematic or methodological way. If they are not, then we don't have a database for legal purposes. Obviously, things are not this easy because the law says that, well, if this systematic and methodological organization is original, and we see it in here in copyright, then there is a copyright in data in the database, but only in the structure. It doesn't extend to the data. So if the data composing the database are not protected themselves, a database is only a form of protection for the structure, for how you have selected or arranged those data, not for the data themselves, which I understand can be quite counterintuitive. And on top of this, we have this weird word that we saw already, the sui generis database, right, which is a purely, so what I said so far, imagine that more or less applies everywhere in the world. There may be differences, but not too marked. In the case of the sui generis database, right, we're talking about a purely European creation. This right, it's what, as a matter of fact, can protect data. So you still have to have the database, regardless of whether your collection is original or not. If you have put, and the definition is a substantial investment in obtaining, verifying, or presenting the data, then you have this additional right that protects extractions of substantial amounts of data. So it's not a single datum that is protected, but if someone else's want to copy your entire database or a substantial amount, then this sui generis database right will forbid that. But obviously, once again, this is just the surface. There are many other considerations to be made, chiefly, for example, the fact that the sui generis database right only protects data that has been obtained, not data that has been created. And this is a very important aspect, because that's triggered a lot of litigation in Europe about what data, when a certain amount of data has been created or obtained. And obviously, don't make the mistake of thinking with a scientific mindset. It's not an epistemological analysis that the court will do often, sometimes they do, on whether you create a data when you record a measurement, or the data already existed, you're just obtaining it from nature. Here, a lot of attention is paid to the competition aspect. So are we created a monopoly right over single source databases? If this is the case, probably the data will be considered created and is not protected. If the same amount of data could be independently obtained through measurement from a competitor, then probably the data is obtained and there is no sui generis database right protection. Sorry, I won't say anything else about this because I understand it's complicated, but I want to give you a dimension of what the law is saying about these aspects and what we cover in the guides. So once we have understood whether our research data is protected, then we can move to the second stage, which is how do I license my research data? Now here, maybe we are more familiar with some of these concepts and topics, and we refer to licenses. Obviously, a common mistake is to think that a license protects something. That's wrong. It is copyright or rights that related to copyright, such as the database right, that protect, and they are automatic, so you don't have to do anything. When you create something, when you write a piece of code, when you write a scientific article, you're already protected by copyright as author. So you don't have to do anything. You don't have even to write down your name or the usual copyright notice with a circle C. All those things can help, but they're not necessary. So copyright protects you. A license is a permission. License means permission. So since the default is all rights reserved, because copyright gives you this property right, then if you want other people to reuse your data or your articles, then you have to give them a permission, and this permission is a license. It can be a restrictive license, as when you buy commercial products, you have to accept that an end user license agreement, or it can be an open license, such as Creative Commons. In this case, we are talking about licenses that allows you always to reproduce, redistribute, etc., etc. But there are conditions. Now, we go through some of the conditions, but these are normally well known. We have other more basic guides that explain how Creative Commons work. If this is a question, we can easily go there. A normal debate here is, I have to apply a CC BY or a CC 0 to my database. It depends, right? So what normally we recommend is CC 0, because if you apply a CC BY, you are requiring attribution for your data when the law doesn't really request attribution, because there are no more rights of attribution for data. So by applying a CC BY, as a matter of fact, you are restricting even further than what the law requires reuse. So that's why normally for data, we recommend CC 0. That said, there is a reasonable community expectation in some areas where you say, well, but I spent a lot of effort in collecting this data. I'm happy to share it, but at least I would like to have recognition, like people to cite me. Well, you can obtain this in two ways. You can do CC 0 and then kindly request that attribution is given to you. This is what Europeana does for certain data sets that they have, for example. But this is not legally enforceable. This is just a request. But is a norm, is a social norm in the scientific community, like when you cite someone. So normally it works. If you really, really want to get attributed, then you can apply a CC BY. That's, maybe not the best of the best of the best of the solutions for open science approaches, but it's still something that if you really want, you can do. You're restricting the reuse of data to some extent, but you're still open access compliant. Important to keep in mind that non-commercial and non-derivatives are non-open access compliant. So if you have to publish in open access because your funders requires it, then you cannot use those conditions. Very quickly to the last slide, also for the sake of time, can I reuse someone else's research data? This is somehow logical follow-up from the previous slide. Well, you need to know whether the research data that you want to reuse is protected or not. Often it is not protected. If it is protected, then you have to look at a license. If this license is CC 0, then you can do almost anything you want. If this license is CC BY, or if the license, sorry, just to follow the structure of my previous guide, if the license is CC 0 plus a kind request to attribute, then legal obligation it's CC 0, but there is a moral obligation to attribute when you reuse the data to the original maker. If the license is CC BY, well, then there is a contractual obligation to attribute in the way that is specified in the original database. Obviously, these are just let's say, the broad picture. It's how you should approach the questions or the problems when they are presented to you as researchers, as PIs, as research coordinators. But obviously, normally, there are much more specific issues and questions, and we are happy to answer them or discuss them further or even include them in the guides. But what is really important is that from the outset, you understand these basic rules. You have to understand that as researchers, you need to have at least a basic understanding of how the law regulates this area, because if you do it, you may avoid certain mistake at the very beginning in the phase of designing your research experiment, that if you made this mistake, it would be much more harder to address them later on. It will be costly in terms of legal analysis, in terms of delay in your ability to publish or share your data, etc., etc., etc. You have to become a little bit, not too much, just a little bit, lawyers as well. This is how science works nowadays, and obviously everyone has its specialties, but as much as lawyers have to understand a little bit of science in order to answer certain questions, scientists have to understand a little bit of law in order to address their problems in the right way, and hopefully these guides can assist you in this. So thank you very much.
Okay, thank you, Thomas. So we have already some questions we will answer at the end, but now we give the floor to Prodromos. Please, Prodromos, can you start? Okay, perfect.
Thank you all.
You can put in presentation mode if you, yes, perfect. So.
Excellent. All right. Thanks everyone, and thanks for being in this webinar. It's always exciting to see that there are many people interested in legal issues, and hopefully they're going to be slightly more enlightened by the time we have finished our presentations. So adding and following up from where Thomas has left us, I would like us to talk a bit about the research data and the GDPR, and ask the question, how open is open? So how basically can we really have open science in relation to the General Data Protection Directive regulation? Because what we very frequently hear is that, okay, this piece of data set has personal data, so what can I do with it? Does it mean that I cannot really release it, or I cannot really release it openly? And I always, when I start talking about this issue, I start with the title of the GDPR, which people don't read. But if you read it, you will see that it has two objectives. One is the protection of the personal, of the natural persons in relation to their personal data, but it's also the free movement of such data. And it's crucial to understand that the objective of the regulation is not to stop the flow of data, but actually to facilitate that. It's just that it needs to happen within a particular framework. So there are 5 elements which I would like to discuss with you today in relation to personal data and open science, in order to see what are some very basic and very frequent questions and issues we are facing, and how can we tackle them. The first thing is to actually understand the setting, to understand what we're talking about. It's not always research that takes place within a single organization, but in multiple settings, so this is crucial. The second thing is to identify what we want to do with the data. The third thing is what is our legal basis for performing any processing. The fourth thing, to understand how this maps on the data management plan or the data lifecycle. And finally, how the data subject may exercise her rights. In this presentation today, I'm not going to go through basic definitions because we don't have the time, and we have quite a bit of that in our fact sheet. But I think we will return with a more comprehensive guide in relation to how I remain compliant to the GDPR while opening my data. So the setting. There are cases when the researcher will actually do research within a research performing organization. In that sense, you're bound by the legal requirements, which is the implementation of the GDPR that has happened in your country, in your member states. And if it hasn't transposed the regulations, which, by the way, they have a direct effect. So the GDPR has a direct effect since May 2018. So it's not necessary for your country to have a national law, but because it contains some elements which require further elaboration by the national legislature, it makes sense to check your national law if it exists. So one framework is the big framework, the laws in your country and the GDPR. And the second one is if you have an ethics framework with your institution. So the first thing you do is that in quite a few institutions, before a research project, internal research project is approved, you need to go through the ethics committee, which very frequently is going to ask questions related to personal data as well. What becomes a bit more complicated is when you have an EU or other collaborative project, and there you need to see the ethics and data protection requirements set by the consortium. Now, this of course has to do with the national law, but also it has to do with third countries. For some reason, the autocorrect made it fourth countries, but I mean third countries. Third countries, we mean countries which are outside the EU. And what does it mean if the data are to flow outside the EU or to come from data subjects that are located outside the EU? And of course, to check what are the conditions of the call for this particular funding instrument. So the important things there is to identify who is the one that sets the conditions for the processing of data. Is it the project coordinator? And if that is the case, how are data being stored between the different partners, and who is processing them, and who is acting as a controller? So in the case of any EU project, you have to answer these questions at the outset of the project. And let me repeat, the key questions is, who is the one who sets the conditions and purposes of the data processing, and that should be the controller, and what are the different roles of the different partners within the project. It could very well be that the data controller is the coordinator, but sometimes you have one partner who's responsible for the infrastructure, and that particular partner may operate either as a controller, if it has indeed full control over the purposes of and the purposing of the processing of data, or may operate as a processor on behalf of the consortium. So what is really crucial is to understand how the consortium is structured, and who is the one who sets the conditions, and who is the one that actually does the processing. Second case, which we increasingly see, is when you have a tender, and there the question is, are you data processor or co-controller? So most of the cases, when you respond, for instance, into an EU tender, you will be a processor on behalf of the Commission, who is going to be the controller. Classic example, the Clarin project, which we have seen in Athena, or the ELRC, actually the ELRC project, which we have seen at Athena Research Center, where the Research Center doesn't operate as a controller, but as a processor. It doesn't set the conditions and purposes, and does not control fully the data, but instead it acts on behalf of the Commission. Similar is when you have a commercial entity that comes and asks you to do some research for them. You're again going to operate as a processor, and that means you need to have a contract that specifically sets the conditions as to how data are to be processed. Two more questions. Who is the data protection officer? If we're talking about the first scenario, when we have the RPO, you most probably are going to have a data processor, a DPO who's responsible for the institution. What it becomes a bit more complicated is when you have a consortium, and then you need to understand how the DPOs of the different organizations work with each other. The other question is how does the DPO relate to the ethics committee? And here I have to mention three, let's say, actors in our drama. you have the DPO, you have the ethics committee, and you may have a compliance officer or compliance people that are responsible for the compliance, which may be a third company. So for instance, it could be that the DPO is let's say, a person who's not part of the hierarchy, but is someone that operates as a controller and as an auditor of the organization and its data protection activities. You have the compliance people, which are people that really go process by process and conform and comply to the law. And finally, the ethics committee, who deals with issues which are far broader than the data protection issues. And they are not just issues that are defined by the relevant legislation. They could be also rules that the institution or institutions have defined themselves and operate as forms of self-regulation. So moving to the next element, which is important to us, is the purpose. What is the purpose of processing personal data at a scientific context? The overall purpose is normally scientific research. A very important article for us is Article 89 of GDPR, where it sets the conditions for what constitutes scientific research. The regulation provides a very broad definition. It doesn't necessarily mean you're an RPO. It could be that you're a private company or a public sector organization. Scientific research is any kind of research you may be conducting, and it doesn't mean that it is commercial or non-commercial. So we have a pretty broad definition of what a scientific research is. Now, the specific type of research may be useful because it explains us and it gives boundaries and limits as to what we can do with this data. So for instance, if I do a social research and I get this data from, let's say, a particular segment of the population in a city in order to, for instance, just a fictional an example, to assess urban and housing conditions, I cannot then use this data for, let's say, direct marketing. So that's why the type of research is necessary and it needs to be defined at the beginning when we try to set the conditions for research. And of course, we start normally with one condition, and as we'll see later, we may change the purpose, and this is a big problem. We have to see how we accommodate it. So what happens when the purpose changes over time? The purpose always has to fit within a particular legal basis, and when the purposes change, then we have to check whether they're covered by the new legal basis. So moving to the legal basis, mostly the GDPR provides 6 basic legal bases and another 10 for specific types of processing. The question that we have here is how do we define this legal basis in terms of research? We normally would say this is public interest, but in cases when we have a tender, the legal basis may be a contract. And when you want to conduct specific research with sensitive data, what we now call special categories of data, we may be talking about consent. I always suggest that we go for consent only. It's not our first option. We will do it only if it's absolutely necessary. And here you see a list of the 6 basic legal bases and what we normally do. The green light, the green color is the public interest because that's our primary legal basis. That is what most research institutions are using. Legal obligation is when you do the research or as part of an obligation you have. We're not going to see that frequently or at all, because normally the public interest legal basis covers us, but it could be that we work under contract or consent in cases like the ones that I mentioned before, contract thing, tenders, consent thing, a very specialized research where you want to do things and you want to absolutely make sure that you get the consent by the data subjects. The legitimate interest is the last one, and I have it in red because I think it's a highly risky legal basis. It means you don't really necessarily ask the data subject if they agree or not. You assume that your legitimate interest is not harmful enough for the data subject, and hence any legitimate interest type of research requires that you have done an impact assessment. I really discourage research organizations to actually do base their research on legitimate interest, they could very well do it with public interest. And if they require specific things, they could go for consent. Here also on this table, what you see is that the groups on the top, there is no discretion. Is part of the things you do because you have to do because of your organization purpose as a research performing organization. The more you go down, there is discretion. You may choose to conduct it or not, but there you are asking the data subject to provide consent as well. So how do we actually do the whole thing? We need to trace the life cycle of the data. We need to follow the data. And we see that different purposes, types of data processing have different purposes and legal basis. And we always need to stay with the legal basis. And that's not self-evident. And in this diagram, which is a very simple DMP, it shows you the problem. I could collect the data, for instance, for, again, I go to my previous example. I'm doing housing research in central London, and I collect this data by different residents. I get it from the data subject, plus I complement them from third party. I may buy some data from a commercial entity, plus I may further enrich those data from publicly available resources from data.gov. Now, once I have this data, I need to read them. So some people need to have access, and I may update or enrich them. So these are forms of processing which need to be covered by my original legal basis. If this is public interest, and if I still operate within the scope of my work, I'm still covered. But if I take this data and I want to change the scope, or so for instance, I got the data using consent forms from the data subjects, and I told them I'm going to keep them for 5 years, but then I need to keep them for another 5 years because I need them for another type of research, then preservation that you see here is not necessarily going to be covered by my original consent, my original database. So I have to seek for other legal bases, and here I would go for research, scientific research and public interest. Similarly, if I am to disseminate them, it really makes a difference how I disseminate them. Am I giving them to a third party? For instance, that's a data processor, a subcontractor. Unless I have this covered at the point of collection of the data, it's very difficult to make such changes. Also, can I pass this data further to other researchers? Is my public interest legal basis going to cover me? In order to be able to answer this question, you always need impact assessment. So what you see is that from the moment of collection to the moment of data sharing, and in between the data management, I need to always have a good grasp of my data management plan and why action A or action B takes place, and respectively how purposes may change and how the legal basis may change. Now, the final thing is that when I operate under Article 89, which is when I'm performing scientific research, which, as I said multiple times, it is a form of legal basis of public interest. Another benefit I have is that the data subject has its rights being limited, and we see that in a series of articles within GDPR. Basically, in most of the articles where the rights of the data subject are defined, we have exceptions in relation to scientific research. The law, the General Data Protection Regulation, identifies 3 types of exceptions that are related: scientific research, statistical purposes, and archiving. In all cases, there needs to be public interest behind it. As I said before, that's a really broad definition. It allows us to do a lot of things, but we need to make sure we stick to that purpose. And also, we need to do 3 more things. We need to have taken the necessary technical and organizational measures in order to protect the data subject, which means we need to have our processes written, documented, and approved. A very good practice would be to have a DMP and have it pass through our ethics committee. That pretty much covers a lot of stuff and also ensures that there are the processes there. A second thing is pseudonymization, not necessarily anonymization. Anonymization is mostly when we really want to decouple the data from the data subject, but this is not necessarily always desirable or feasible. So pseudonymization is an option, and this is something explicitly mentioned by the regulation. And the condition which actually makes us understand whether we are in or outside the scope of the regulation is whether any kinds of request from the data subject to exercise their rights is likely to render impossible or seriously impact the achievement of the objectives of that processing, which pretty much gives us a lot of space for actually not having always to give access or explain why we're doing X or Y with the data. Having said that, this needs to be not unnecessarily or abusive. I mean, this is something we need to do within the scope of goodwill. And of course, it is necessary to always have to also have notices and provide the data subject with the relevant information. So to sum up, what we see is that if we do personal data processing within the context of the open science, it is something that could be done. It is actually encouraged. However, it means we really need to focus on the data management plan and make sure the purpose and the legal basis are always justified there. So that's it from me. Thanks very much.
Many thanks, Thomas and Prodromos. So now we can start with the questions and answers. We have already a question in the chat, so maybe we should start from that. And then we have two slides where we have gathered some of the questions that we have collected from the registration form. Okay, so we have some highlights here that Thomas and Prodromos will reply. But let's first check the chat, I think, where we have a question. Okay, it's here. So Thomas.
So the question, it's about the CC0, CC BY, and the fact that the attribution kind request, it's not always, or I think seldom, the question says followed. Yes, that's why we're presenting two options, CC0 and CC BY. But the main question here, and I understand it can be frustrating for the expectations of you as researchers, is why do you want attribution, right? There are areas of law, and again, here I'm just explaining you the law, I'm not giving an opinion, that say, well, your contribution here corresponds to an original work. Therefore, you have economic and moral rights, and one of these moral rights is attribution. In that case, the law tells you, well, because you're putting the rhetoric would be part of your personality into the work, then you deserve, from a moral point of view, to be recognized as the author, and therefore attribution has to be given. So, for example, when there is you use a work for purposes of, say, quotation, then you have to attribute. The law evaluates data, and we're talking about data here, differently. In fact, data, as we saw, very often it's not protected at all. You don't like it? Well, we have to see what is the scope of the law and what is the scope of the of science and open science in general. Is it the promotion of the personality of the researcher, or is it the promotion of science in general? So it's a public or a private goal that it's being pursued here. The law, for the law, the answer is quite clear. Data, raw data and structured data is not protected, therefore you can do whatever you want. Now, if you decide to limit it contractually, even with a contract that is quite liberal, such as CC BY, you are reducing the space. And therefore, the main recommendation for data is CC0, because it's the license that mirrors better what the law considers to be protectable or not protectable. That being said, in our guides, we clearly say, well, if you feel strongly about attribution, then use the CC BY. But you know, what I would invite you to do, it's not to acritically, as researchers, apply CC BY. Think of the consequences. If you think, well, you know, in this case, you know, it's just some data collected there, there is no really much value in it, why restrict them further? If you feel strong, really strong about them, apply a CC BY. I think it's suboptimal, but still fully open access and open science compliant. The important thing is to avoid more restrictive conditions such as non-commercial.
Okay, thank you. So, Thomas, let's try now to do the exercise. So let's have maximum like 50 minutes. I think it's not easy to do it, to answer all the questions, but with your effort, Thomas and Prodromos, let's see if we can do. So we have here like a set of questions that people put in the registration form. Some of them ask us to talk about legal issues versus opening up data, research data, so patents and open data. But we have two questions here about, I think you have already addressed this during your presentation about so raw data and the specific. So, do you have anything to?
Let me just say that, you know, let's not try to, you know, be like to try to create. Well, how do I put this? I don't know. Anyway, we have, if you want. So one thing is to say that research data, as such, they are not protected by. Let's say they do not qualify as a database for the purpose of the law. But what the law requires, it's very minimal. So there is a question saying, what if we structure the data in a spreadsheet of observational measurements? That could be enough. You know, the important, you know, it's not the spreadsheet that it's the decisive element here. It's how you structure, so how that data is organized. So the usual example here, even though it's a bit, you know, old school, it's yellow pages and white pages. So white pages is a collection of data, names and phone numbers, but this collection follows like an alphabetical order and is exhausted. So there is no selection, and there is in how you choose the data, and there is no rearrangement in how you present them. So white pages traditionally are a good example of a database that is not protected. Yellow pages, because you apply some sort of selection to the data, you don't collect everyone's name and phone numbers, but just someone, and you follow some sort of structure there. And then when you reorganize it, you may classify it under, I don't know, plumbers, electricians, etc., etc. That's a very minimal level of originality in your structure, but it might suffice. Mm-hmm. Now, the thing that we have to understand here is that this example, for how we presented it, works for copyright. So white pages not protected by copyright, yellow pages they are. But what copyright protects here is the structure. So how you design the selection and arrangement, which means that in the case of the yellow pages, a competitor could not reuse your structure, so the way in which you selected and presented, but he could reuse your data. So, you know, the single data, well, not the single, the entire data, right? For corporate purposes, because corporate doesn't protect the data collected, only protects the structure. If on top of that in Europe, there is a substantial investment in obtaining, verifying, and presenting, and this could happen both for white pages and yellow pages, then you might have a sui generis database right, and this would prevent a competitor from extracting the same amount of data. So this is the difference. What you have to do, so if you want to protect your data, just instead of publish them in a completely unstructured way, just give it some structure. That's probably more than enough to make them protectable and apply a license. Keep in mind that you're moving away from open science principles though. So that's something you have to keep in mind. If your goal, if you really feel strong about attribution, then, you know, make sure you present, you public, make available the data in a way that is protectable, but apply CC BY 4.0 and apply it properly. All this information is contained in the guides. But otherwise, CC 0 might be a much better choice. So keep all these variables in mind.
Yeah. Yes, I think it was really explicit what you said, and thank you for that. So if you want to address any other topic here in these questions that I think you have already answered, so let's we can come back here, but let's now move to the.
I think there is just one thing, and then we can move to the data protection. Keep in mind the other thing, that copyright belongs to the author. The sui generis database right doesn't belong to the author, belongs to the maker, the person or entity who makes the financial investment or takes the risk, which is normally the university. So, you know, the point is, if you want to play the game of the law, make sure you know the rules of the game, because you might have noble intentions, but you might enter an area that, you know, you don't know very well, and it may backfire. So make sure what you want to do and do it properly.
Okay, so Thomas, please take a look to the question and answer box where you have some more comments from Mario about the question that he have put. So, but now we move to and then you can answer if you have something to add. Now we move to another set of questions that we have gathered here from the registration form, more or less related with so privacy issue, personal data. So Prodromos, do you want to?
Yes, and I think these are in a sense very classic questions. I tried in the presentation also to bring an example from social science research. As I said before, it's absolutely crucial to have a clear data management plan and make sure you pass through all necessary steps in each one of the three main, let's say, parts of a data management plan. So you need to be absolutely clear when you are to obtain the data, to actually know what you're going to do with them. It seems it's very similar in that sense with how you do a copyright strategy. But when you, at the point of data collection, you have to have made your mind as to what you're going to do with this data. Are you just going to go do research within your RPO? Are you going to be part of a consortium? Are you going to publish the whole thing? Are you going to publish the questionnaires as well? And this is once you start with what you want to do. So for instance, let's say I want to have the data forever and be totally open. Or it could be I want to have the data just for my research institution. And I think both options are not really there. In reality, you're always going to share your data with someone. And in reality, you're not going to be able, for all sorts of reasons, to fully open everything. So you need to understand what is the purpose of the whole thing. Why am I doing that? So if it's social research, which is about writing a paper, but it's also something which needs to be further verified by other researchers or be part of my data collection in my institution, or I'm doing that as part of a European project, then I need to know which are the ethics rules within the context of my research. So I use a housing example, but it could be that I do public health research, or I do research that relates to minority groups, or anything that has special categories of data, what we used to call sensitive data. In that sense, of course, I have to comply with the law. It most probably means I would need to get consent. It would mean that the consent forms have to be very thoroughly checked by your legal department, and also to be seen by your DPO. They will also have to pass through your ethics committee. You should have a standard process as to how you clear things off legal and ethical issues, and then you proceed with your research. That sometimes sounds awfully bureaucratic. It may take ages, but I'm afraid there's no other option if you're doing research that contains personal data. Now, in terms of patients' data, it becomes a bit more difficult, because we don't just have the personal data rules. We're going to have ethic rules which relate to the university, and ethics rules that may relate to the hospital or the national health system of that particular country. And here, it's not only the data. If you're dealing with biobanks, you also have another set of regulations that relate with biomaterial and material transfer agreements. So I'll leave that totally. I consider that outside our discussion. If we talk about simple patient data, you check what is the data protection rules in your country or your region. If we talk about a transnational project, you check the ethics committee of the university or the research center, and the ethics rules and committee of the hospital. Now, can we anonymize them? It depends really. If this is not, I would say that pseudonymization tends to be better, because you can trace it back, and this may be relevant to your research. But anonymization is not just, or pseudonymization is not just a technical process, it's very much a procedural thing. So it has to do with how you have access to this data and how you return to them. Finally, it could be that the research itself does not allow you to anonymize. You need to have things which make the person identifiable, and hence, though you may remove the name, you can still identify the person. Let's say it's a woman who's in that particular region. She's over 80 years old and she has PhD. So it's probably someone, it's probably Mary. So you have a lot of these things, especially when you deal with genetic data. What has happened with the pharmaceutical company? Of course, in that case, you may even be a processor, not a controller. It may provide you limitations that have to do with sharing or archiving, but these are not going to be necessarily limitations related to personal data or ethics. They will be confidentiality, trade secret, or IP limitations. So we also need to understand that the flow of data is not only limited by legal rules on DP or ethical rules that self-governing boards set, but it could be also property rules. And here it's very important that we also have the Trade Secrets Directive. It's a very recent thing in the EU. Most countries are transposing it now, and it places quite a few restrictions on researchers conducting commercial research. How do we share data if they are from many different institutions? Normally, you have model consortia agreements, which should be your Bible. What happens, unfortunately, is that people use still the very classic consortium agreement that the EU provides, which has been built for industrial property. It's extremely heavy for copyright. In terms of data protection, it's basically box ticking. And in terms of how you deal with trade secrets and how you deal with sharing of property, it lets it quite open to you to decide. What I always suggest is to make sure that you understand what the work packages do and what it means for the type of processing and the purposes, and then identify how we can actually make sure that we have a DPO for the project and how it relates to the different DPOs of the involved organizations. Finally, in terms of ownership, if you have personal data, they are not owned by the individuals involved. The individuals involved have rights that relate to personal data legislation or personality, which are not the same thing, they are different things, or they have rights that come out of self-regulations, such as the ones that an ethics committee would set or a professional body would set to a sector. So please, this would help you a lot don't confuse personal data with property rights. They are very different. And again, to emphasize three things which people always confuse: confidential data, they are not necessarily personal. So it could be corporate data that have to do, let's say, with the clinical trials. They don't necessarily have personal data, but you know, the company that paid you doesn't want you to release them. They are protected contractually and through the trade secrets legislation. Secondly, you have personal data and a subcategory, sensitive or special category of data. They are personal data. These are protected through GDPR and national legislation. They are also regulated by codes of conduct and ethics rules that the organizations or sectors impose on themselves. And then you have personality rights, which are broader than personal data, and they may have to do with rights on images or rights that actually relate to the personality of the individual. And then finally, you have hardcore property rights, intellectual property rights, copyrights related rights, sui generis rights from the side, let's say, of the things that look more like author's rights and similar types of things. And then you have industrial rights, patents, trademarks, trade secrets, plant varieties, protected names of origin, etc. So these are hardcore property rights. So please don't confuse these three things: confidentiality, personal data, property rights, intellectual property rights.
Yeah, thank you, Prodromos. I think it was really helpful, your input. So, Thomas, I'm not sure if you want to say something about the second comment from Mario here in the chat, because it's more on the...
I don't think I see it, you know. I see the chat, but I only see the original one.
It is in the question and answer. It's here. Can you see my screen now? It's in the question and answer.
Can you read it? I see your screen, but I don't see which one is it.
Okay, maybe you don't. So, but you don't see the question.
Okay. Now, sorry.
Okay. Okay, so I think so Thomas will reply to this.
Well, it's a comment, you know.
Yes, comment.
The only one thing to keep in mind is that if it is raw data, and again, I'm pretty sure that it is structured in a database, if it is not structured in a database, because if it is raw data, and this is an example of what Prodromos just said about property rights. If there is no underlying property right, and you apply a license, any kind of license, Creative Commons, but also a closed license, then it's only the contract that binds the two parties. There is no underlying property right. It means that any good faith third party is not bound by the contract. So it's not bound by attribution. So the reason why they're doing it, it's because there is a perception of a community norm, not a legal requirement. Okay? So once again, I understand why you may want to do that. There may be better ways to do that. Metadata could be another way, but you know, don't don't misunderstand the law, because it's complex. So yeah.
Okay. Not sure if you want to say something to finalize. I will just finalize the webinar. But Prodromos, Thomas, if you want to have a final remark, just say it now, and then we will close the...
No, I think we'd like to hear any possible feedback, both on the webinar and on how to develop further the guides, I think.
Yes, this is important, and we can say we can do something after the webinar based on on those that have
I
participated.
think the copyright is quite well developed. What I would be very interested is from this presentation to get some feedback. What would people like to see in terms of a guide on personal data? I try to be extremely concise because of the limitations in time we have, but I think we would greatly appreciate some indications as to what I think they are mostly interested in, so that we can then produce a guide which is more oriented to these needs. I try to mention the basic things. How do you set up in terms of data protection a project? What you should take care of when you conduct the project? Which are the main issues related to the DMP and Open and GDPR? But it could be that there are other things people are interested in. So please give us feedback.
Yeah. So many thanks. Just before I close this webinar, I just want to do 3 final remarks. So we will ask you your contribution and your comments. It's quite important for us to have your feedback. But I think it's important also to highlight that the way that we are trying to organize all these new guides around legal issues, but also others around open science, research data management, is trying to have real user questions, so real needs, so real doubts, and then we can place it as a question and we try to address and answer and put information via these guides. And as we have the national open access desks, we have a strong network delivering several presentations, several training in different countries, and via the NOADs, the National Open Access Desks, we are trying to collect this kind of questions and doubts, and it's why we are putting also the guides in this form. So the other things that Thomas already presented, it was about the improvements that we want to do about the content that we have from this legal guide. So we have all the content, the text, it's fine, the structure is really good, but we want to improve a bit. We want to create some infographics, and we want even to create some more like media and videos around the content that we have, because then you can reuse it in training activities in your institutions, or to share with your colleagues, or just for you to learn more. And the last one is to invite you, as we have here a large audience. I want to highlight that we will have the Open Science Fair Conference in 2019 in September in Porto. All the conference is organized around workshops and training sessions. We opened yesterday the call for proposals for workshops and posters and demos also. So we don't have like papers traditional conference, it's more an interactive conference. So it's why I'm inviting you, because for sure we will have also we will address also some issues related with legal issues in open science. So put in your calendars, if you can make it, just participate and come to Porto, because I'm in Portugal right now, to participate in this conference. So from our side, it's all. Many thanks for your participation. We have already the slides available. We already shared with you the links, but we will send it via email, and they will be available in the normal communication channels from OpenAIRE. Please follow the Twitter of OpenAIRE, follow also the newsletter, because it will be via these channels that we will publicize the new support materials that we will deliver in the coming months. So many thanks, Thomas and Prodromos, for your effort to do this great webinar. I think it was very good and helpful. So many thanks, and see you. Bye. Bye all. Thank you for your participation.
Thank you. Bye-bye.
Bye, thank you.
Bye.